We now come to Lively's opposition to Wayfarer's motion to exclude the testimony of Professor Dina Mayzlin. And I am not going to be referring to her as Professor all the way through this video. Okay, so this is the digital marketing, analytics, etc. type of expert. And Nicole Alexander has been brought in to rebut this expert amongst, I think, a couple of others like Aaron Carlotta and Ashley Humphreys, I want to say. So I think this one, yeah, we'll go through this because when I went through the motion, Wayfarer's motion to oppose Lively's request to have Nicole Alexander excluded, it was quite interesting what they were saying about, especially Dina Mayzlin and Aaron Carlotta. And yes, I know I'm going to see it in the comments, but yes, I have seen Shusty's video as well on Aaron Carlotta's data. And she's gone kind of, compared and contrasted that to the analytics that we can actually access for our individual videos. And I will be talking about that when I get to Aaron Carlotta. So I will factor that into whatever I say. But we will get there. I'm not sure if he's next, actually. Okay, Dina Mayzlin. Professor Dina Mayzlin's testimony is admissible under Rule 702. Drawing on nearly 3 decades of subject matter expertise in digital marketing, analytics, and economics, using the very methods that she teaches in this nation's highest rank higher learning institutions and applying well-established and analytical techniques, including her own published peer-reviewed model. Professor Maslin designed a scientific methodology in this case to determine 1. Whether there is evidence of manipulation of online conversations financed and or executed by defendants, and 2. If so, the manipulation's impact on Miss Lively's brands, namely Betty Buzz, Betty Booze, and Blake Brown Beauty. She concluded that defendants' campaign to bury, destroy, and discredit Miss Lively played a central role in shifting consumer attitudes against her. As a result, all 3 of Miss Lively's commercial brands saw drastic declines in sales. Professor Mayslin's opinions are based on and reliably apply social science methods and techniques that satisfy Rule 702 and Dalbert. Professor Mayslin's testimony will be helpful to the jury because it will establish the adverse action element of retaliation and aid in calculating damages. Notwithstanding their hyperbolic rhetoric, defendants do not raise meaningful challenges to Professor Mayslin's actual methodology. Instead, defendants repeat their now familiar common sense theories of organic causation and offer a generic critique of using artificial intelligence, large language models, but LLMs offer a reliable, objective, and scientific method for identifying and classifying topics from large volumes of social media text, and Professor Mayzlin used transparent and reliable principles to direct the LLM in this case. I don't know if it probably is the same in America, but in the UK, LLM, that refers to, it's like the master's degree in law, something I actually have. That's where my mind goes. Every time I see LLM, I keep forgetting, we're talking about a different thing. Indeed, during her 5-hour deposition, defendants posed virtually no questions of Professor Mayzlin. Defendants posed virtually no questions of Professor Maslin regarding either the LLM suitability in large-scale text analysis or whether she applied it correctly here. Moreover, despite having access to all of Professor Maslin's raw data, coding, LLM prompts, and findings for more than 6 months, defendants cannot cite to a single hallucination in Professor Maslin's dataset of over 1 million pieces of content. There is a reason for that. Unlike the horror stories cited in defendants' AI cases, Professor Maslin did not direct the LLM to assemble or generate content. Instead, the LLM was limited to classifying text from a dataset assembled entirely via a collection method that defendants do not challenge, with results verified manually. Defendants mock certain results of that classification, but tellingly, the sum total of the LLM's errors that defendants have identified after months of scrutiny amounts to a statistically insignificant error rate of 0.91%. Apart from their irrelevant attacks on AI hallucinations that have not occurred here, defendants' core argument is that the jury can simply default to common sense to decide why a series of online narratives attacking Miss Lively's reputation and character happened to catch fire on social media in mid-August 2024. But defendants' self-serving gut feelings that the public must have organically stumbled upon and chosen to engage with, their favourite takedowns of Miss Lively, are useless to the jury. What is of great unity? Favourite takedowns? I'm surely we just quote back Lively's own words to her. What is of great utility, by contrast, is the objective statistical analysis of more than 1 million social media posts offered by one of the nation's leading experts in the manipulation of online content about celebrities and their brands. Defendants fundamentally misunderstand Professor Mayslin's expertise and methodology in this case, Ms. Lively's claims, and how damages are calculated under FEHA. I hope the judge grants Wayfarer's motion for judgment on the pleading, so most of this shit becomes irrelevant. In sum, it is defendant's Daubert motion, not Professor Mayslin's opinions, that is based on ipse dixit, without any support in relevant law, industry expertise, literature, practices, methods, or math. The court should deny defendant's motion and admit Professor Mayslin's testimony under Rule 702. And for some people who have followed me for long enough will know, because I've already said this, but for those who haven't heard me say this, ipse dixit is it's Latin. It's obviously Latin, but it's a legal term for like an unproven statement. Okay, so we go to the background. Professor Maslin is a leading academic expert on online word of mouth, digital conversations, and manipulation of online content, with multiple highly cited publications in top journals such as American Economic Review, Marketing Science, and Journal of Marketing Research, including foundational work on the causal impact of manipulated online content. Oh God, I've got a cold, so I'm sorry if I'm struggling to say long words here. Professor Maslin empirically investigates these topics, including by creating, implementing, and analyzing related scientific models. Professor Maslin has won 5 top awards in her discipline, one of which she was awarded 3 times. Holding 2 degrees from MIT, Professor Maslin has spent decades teaching undergraduate, MBA, and PhD courses on digital marketing, analytics, and quantitative modeling at Yale and at the University of Southern California, where she is now the Robert E. Brooker Chair in Marketing. She has served as an expert witness on numerous occasions. It is undisputed that Professor Maslin possesses the knowledge, skill, experience, training, or education necessary to qualify her as an expert in online word-of-mouth manipulation and its commercial effects. Because defendants do not challenge Professor Maslin's qualifications, nor can they, this opposition focuses on the reliability and relevance of her methodology. Okay, so now to the argument. Professor Mayslin's testimony meets all of the conditions imposed by Rule 702. Her opinions and methodology are reliable. Professor Maslin applied well-established empirical methods for analyzing large-scale text data to a dataset of over 1 million online conversations, and her methods are consistent with peer-reviewed academic literature. Professor Mason's testimony is also relevant and helpful to the jury. It will illuminate the existence, scope, and commercial impact of defendants' coordinated digital smear campaign, matters that no lay juror could plausibly discern from the raw data alone, thereby establishing both the adverse action element of retaliation and the basis for calculating Miss Lively's substantial damages. Defendants' objections rest on mischaracterizations of Professor Maslin's methods, inapplicable fears about the uses of AI that simply do not apply here, and disagreements with Professor Maslin's conclusion, all of which go to weight rather than admissibility and none of which warrant exclusion. Professor Dina Mayzlin's testimony is reliable. Professor Maslin's testimony is reliable under Rule 702C to D because it is the product of reliable principles and methods which she reliably applied to the facts of this case. Professor Maslin's opinions are the product of reliable principles and methods. You could start a drinking game. Every time I say the word reliable, we have a shot. Professor Maslin's research is well grounded in established academic literature. Professor Maslin roots her investigation in academic literature that 1. Online conversations casually influence consumer behavior and product sales. 2. Celebrity reputations and affiliated commercial brands are inextricably intertwined, such that reputational shocks to a celebrity can transfer directly to the brands they own. And 3. Online conversations can be strategically shaped and manipulated to influence commercial performance. Professor Maslin's expertise in digital marketing, analytics, and economics underlies her methodology. Professor Maslin's methodology applies her own published, peer-reviewed research on the causal effects of online word of mouth and the manipulation of online reviews. Contrary to defendants' suggestions, Professor Maslin did not apply AI tools to collect her dataset. Instead, Professor Maslin collected her own data using reputable and unchallenged tools and assembled a large sample size of over 1 million online conversations retrieved from 3 major social media platforms, X, Reddit, and YouTube, from May 1st, 2024 through February 28th, 2025, which provided a baseline period and a post-discontinuity period consistent with the study's causal inference framing. And I can see the argument, because when we were reading the opposition to excluding Nicole Alexander, one of the things that they brought up was, Lively's moaning that she, her the data that she collected only goes as far as February 2025. And that was true. When we read Lively's Daubert motion to exclude Nicole Alexander, that was one of the complaints that she kind of brought up. Well, it doesn't, go beyond February 2025. Wayfarer pointed out that Dina Mayzlin herself also only collected data up to February 2025. And here's Lively confirming that. Professor Maslin then applied mutually reinforcing analytical techniques that are reliable and accepted in her field. Specifically, she deployed latent Dirichlet allocation. I'm sorry if I've got that wrong. Topic modeling, 2 different LLM approaches, a type of artificial intelligence or AI, and manual review applied to validate both LLM tactics. Professor Maslin used LDA, which is a well-established methodology for identifying and extracting underlying topics from unstructured text, including social media content. LDA infers patterns directly from the data without predefined categories or human judgment, and it offers a systematic, data-driven, and impartial means of summarizing large volumes of text. Just make that a little bit bigger. Professor Maslin further used two different LLM approaches to classify online conversations into public sentiment categories: positive, negative, neutral, and mixed. An unsupervised method and a direct method. For the unsupervised method, Professor Maslin did not guide the model regarding which emotions to identify, giving the model the freedom to choose the most appropriate emotions applicable. The results were manually reviewed and grouped. For the direct method, Professor Maslin instructed the model to classify sentiment into one of the four predefined categories. Finally, Professor Maslin conducted a separate thematic analysis of online conversations using the LLM to evaluate whether four specific narratives from defendant scenario planning document were echoed in online conversations, deploying intentionally conservative prompts. Professor Maslin assured validation of results through manual review, both for the LLM's sentiment classification and thematic analysis. The human reviewers adhered to a blind coding protocol. Without any preconceptions, the human coders were given detailed written instructions and classified conversations independently. A random sample of 300 online conversations was selected for manual validation of the LLM sentiment and thematic validation. With respect to the sentiment classification, the LLM and manual reviews achieved an 85% agreement rate when grouped into negative and non-negative sentiments. Importantly, the LLM favored defendants, classifying 25.3% of the conversations as negative, while the human reviewers classified a higher percentage, 27.7% of the conversations as negative. With respect to the thematic classification, the LLM and manual reviews yielded an overall agreement rate of 84%. This close alignment supports the conclusion that the LLM-driven methodology produces aggregate sentiment trends that closely mirror those obtained through manual classification. The LLM thematic classification approach was shown to be even more conservative than the LLM sentiment classification approach. It identified only 2.7% of the sample as agreeing with at least one manipulated narrative, compared to 18.3% identified by human reviewers. These empirical results indicate that the LLM understates the prevalence of both negative sentiment and manipulated narratives. Ultimately, the data revealed, first, that there were two distinct spikes in the volume of online conversations. One around early August 2024, and two in late December 2024, which extends until February 2025. Second, the data showed that the themes observed in the spikes of negative sentiment in early August 2024 and in December 2024 are closely related to the manipulated narratives about Miss Lively and narratives from media articles seeded in early August 2024. Based on the data, Professor Maslin concluded that 1. Defendants manipulated online conversations about Miss Lively, which 2. led to the lowered sales of Miss Lively's commercial brands. As further indicia of reliability, to allow reproduction and verification, Professor Maslin submitted her full raw data and code with her findings. By failing to challenge their validity, defendants effectively concede that all but one of the principles and methods Professor Maslin used here are reliable. Their sole objection is to her use of the LLM, arguing that because Professor Maslin used a type of AI, her data is inherently unreliable, and her opinions must be excluded as a matter of course. In doing so, defendants critique an application of AI that Professor Maslin did not deploy, and ignore the scientific acceptance and applicability of LLM models to large-scale text analysis. Professor Maslin used the LLM model GPT-4o as a data classification tool to analyze existing text, i.e. the data that she collected, not to retrieve or generate new information. She used the LLM to assist in classifying a large amount of reliably sourced and independently gathered data. The LLM did not generate the underlying data, nor did it generate descriptive summaries or aid in drafting Professor Maslin's findings or conclusions. The LLM only classified the large number of online conversations, which is a task that would be impracticable to accomplish through manual review. This practice is widely accepted in the social science community. Given the tone of their Daubert motion, it may come as a surprise that during their deposition, defendants asked Professor Maslin a grand total of 3 questions regarding the LLM, 2 related to the reliability of the LLM as a tool for large-scale text analysis. And as she explained then, and has demonstrated via citations to the academic literature, LLM is the state of the art now in the technology and also in academia. And GPT-4o is probably the most popular model for that. It's really effective, which is why it's taken over in such a short amount of time. Professor Mayslin's report, citations to academic literature and testimony, more than established that the use of LLM, particularly when constrained to classification and verified manually, is reliable methodology. None of defendants' authorities hold otherwise. Their cases describe completely unrelated generative AI use, wherein AI created false information wholesale. That is not how Professor Maslin used AI here, and as discussed below, she applied the LLM model reliably via objective standards. Professor Maslin's testimony is admissible because she has reliably applied established scientific principles and methods in this case. Professor Maslin reliably applied established principles and methods in statistics, machine learning, and text analysis to a large body of data. Her approach is consistent with modern empirical research on large-scale text data. Contrary to defendants' insistence, every single step of Professor Maslin's analysis was not only documented and well explained, but it was reliably applied and rooted in established literature, as the chart illustrates below. I'm not going to read all of this. But you could pause the video and just go through it if it makes sense to you. Oh, goodness. Right. Professor Maslin relied on a dataset of over 1 million online conversations, applied a structured multi-step analytical framework grounded in established marketing and empirical research, including large-scale text analysis, thematic identification, and sentiment classification, coupled with manual validation to reach her aggregate conclusions. This is above and beyond what is needed to show that Professor Maslin reliably applied established scientific principles and methods. Defendants do not rely on any academic literature or expertise to attack the reliability of Professor Maslin's opinions. They rely instead on unsupported logic and irrelevant cases. Defendants also spend the bulk of their opposition challenging Professor Maslin's conclusion that defendants are responsible for manipulating the online conversations around Miss Lively's, shifting the public sentiment negatively and thereby likewise driving down the profits of her brand. Throughout pages, they set forth their own theories for what they think best explains the sudden public fascination with negative online content about Miss Lively during the periods of spikes. But it is well settled that, in evaluating a Daubert motion, the district court must focus on the principles and methodology employed by the expert without regard to the conclusions the expert has reached, or the district court's belief as to the correctness of those conclusions. Each of the defendants' arguments amount to disagreements with Professor Mayslin's opinions, all of which go to weight rather than admissibility. Professor Mayslin's methodology follows accepted scientific processes and is consistent with her prior published work. Defendants argue that Professor Maslin has never previously applied this methodology and appears to have concocted it solely for purposes of this litigation. The courts have consistently held that an expert may develop a methodology for litigation purposes and apply accepted methodologies in new ways, provided they do so based on reliable principles and methods. And for all the reasons stated supra, Professor Maslin reliably applied established principles here. Defendants also go to great lengths to distinguish Professor Maslin's AER report from her methodology here, ignoring that 1. Professor Maslin relied on other literature, 2. The methodological framework underlying both studies is exactly the same, and 3. The two studies are alike in many ways. For starters, defendants could have explored during Professor Maslin's deposition all the ways in which her study here derives from an objective scientific process. They failed to do so. Professor Maslin's methodology, both in her AER report and here, comes directly from the scientific process described in a highly cited research paper that provides a framework for large-scale content analysis. As illustrated below, consistent with the gold standards of text analysis, Professor Maslin's methodological framework in this case, like her AER report, included exploration, topic extraction, sentiment classification, narrative and thematic classification, and validation, all denoted in green. Okay, so I'm just going to leave that there for a second, and you can pause and have a look. I'm not even going to try to explain it because I don't understand it. Professor Maslin followed this same foundational framework in both the AER study and this one. To illustrate in both Professor Maslin, 1. Independently collected data, there hotel reviews, here social media posts. 2. Tabulated and aggregated the data, there by reporting mean, minimum, and maximum valuations for reviews, here by volumetric averages, counts, and charts. 3. Use systematic analytical procedures, there regression analysis, here LLM and LDA-driven analysis. 4. Compared against baselines, there to platforms with weak and strong content policies, here to before and after narratives, sentiment, and seeded articles. And 5. Validated results, there using statistical significance tests, here using human validation and confusion matrices. Okay, so they're just comparing, like, because I know Wayfarer threw a bit of shade, said, well, she doesn't know, she's got no experience in this, she's just dealt with hotel reviews. So they're kind of like trying to compare and contrast, like, well, the work she did for those hotel reviews is similar here because I did it, and then they're going through point by point, all the ways that there is overlap, which is a fair thing for them to do. Thus, contrary to defendants' arguments that Professor Maslin's expert report in this case lacks robustness, checks, or formal statistical methods. The methodology underlying the two studies is the same, and sections VC2 and VC3C of Professor Maslin's report thoroughly discuss her checks and balances. Because each study is calibrated to different problems, it should come as no surprise that they applied principles in different ways. Professor Maslin need not replicate exactly her previous work, she need only apply established principles reliably. To demand otherwise would stifle scientific innovation. Okay. In fact, the literature itself recognizes that variation in methodology is not only normal, it is expected. Professor Maslin reliably applied the LLM model. Additionally, Professor Maslin reliably applied the LLM tool. After baselessly wholesale rejecting the use of the LLM as a reliable text analysis tool in the first place, defendants attempt to cross-examine Professor Maslin on paper with questions they did not bother to pose during her deposition in an effort to undermine her application of the LLM. I find this wild that she's moaning about Wayfarer attempting to undermine after what she put in the Jennifer Freyd opposition. Was it Jennifer? Or, yeah, it was. But just to sort of say, all the exaggeration like that had me so upset. But remarkably, defendants cite no legal or scientific authorities undermining the methodology, no errors they discovered in attempting to replicate her work, and no statistical basis for rejecting her findings. Defendants cite to random and unverified public accounts of using GPT-4o in a manner that produced errors in coaxing the tool to follow user prompts. Despite the fact that Professor Maslin, an expert in her field, encountered no such difficulties. And they point to an inapposite case where the court concluded expert opinion regarding a damages model that the expert did not test, whereas Professor Maslin did here, to assure that it would provide reliable results. Professor Maslin controlled every step of the LLM process, inputting independently collected data, directing the model would disclose prompts, constraining it, and testing its output. Professor Maslin did not use the tool to generate new content, wherein the risk of hallucinations arises. Instead, the LLM's findings rest on a dataset that Professor Maslin personally collected using Pulsar, the reliability of which defendants have not contested. Drawing on her expertise, Professor Maslin then configured the LLM in a manner likely to minimize the possibility of random variations in the LLM's responses, and created tailored prompts that gave the LLM meticulous instructions for the output, alongside specific formatting instructions to ensure consistency in output. Because it does not generate content, the LLM's worst error would be misclassifying a conversation. Professor Maslin accounted for this risk in 3 ways. First, she wove her expertise into specific and cabined prompts. Next, Professor Maslin used 2 approaches to classify the sentiment of online conversations, an unsupervised method and a direct method. She observed that the trends between the 2 were very similar, further assuring the accuracy of the results. Finally, Professor Maslin conducted a manual validation of the LLM results, wherein 2 neutral human reviewers who were blind to the case and given very detailed instructions independently reviewed a random sample of conversations. Here too, there was close alignment between the classifications of the LLM and the human reviewers. Professor Maslin's methodology was scientific, objective, replicable, and reliable. It is also not the only analysis Professor Maslin performed. Professor Maslin also used an LDA model, another well-established methodology for identifying and extracting underlying topics from unstructured text, including social media content. This tool too found similar results. Defendants claim that the LDA model contributes little to Professor Maslin's conclusions, dissecting her multi-pronged approach into a bare component. But Professor Maslin stresses in her report that to understand the potential effects of online conversation manipulation on Miss Lively's personal brand and commercial brands, it is important to first examine public perception before August 2024, and to do so, she uses the LDA model. During her deposition, Professor Maslin testified, "My report works as a portfolio of analysis, describing the 6 or 7 different analyses she conducted." Regardless, the degree to which Professor Maslin relied on the LDA model has no bearing on the reliability of the LLM model. Both are independently reliable, and here were used together and reinforced one another. Importantly, defendants have had many months with all of Professor Maslin's data, LLM prompts and methods to demonstrate errors in her statistical analysis. They have failed. Defendants do not provide a single example of a hallucination in Professor Maslin's study, nor any reason based on mathematical or scientific principles to challenge her methodology's validity. Instead, defendants resort to pseudostatistics. They identify a series of social media posts that they assert were misclassified by the LLM, claiming that 2,801 conversations report only that Miss Lively filed this lawsuit, while another 492 posts were misclassified as negative when they should have been classified as positive. But even accepting defendants' assertion on its face that these 3,293 conversations should have been excluded from the corpus of 361,050 negative conversations identified by the LLM would yield a statistically insignificant error rate of 0.91%, less than 1%. And these 3,293 conversations amount to just 0.29% of the 1.1 million conversations Professor Maslin analysed. None of this has any meaningful effect on Professor Maslin's aggregate results, and none of it provides a basis to exclude her testimony. Ultimately, the issues defendants have raised are quintessential topics for cross-examination, not grounds for excluding the testimony. That is especially true here, where Professor Maslin's study focuses on broad trends, not individual posts. Defendants separately argue, without any citation to literature or expert testimony of their own, that a manual review of 600 posts, 300 each for sentiment and themes, is insufficient. But that assertion is ipse dixit. The relevant question is not whether raw numbers are facially impressive to counsel, it is whether a chosen sample is defensible, representative, and capable of exposing error rate. The answer to each of these questions here is a resounding yes. First, defendants' sampling criticism conflates two different things. Analysis of the full sample, that is, the corpus and validation of the coding, the sentiment and thematic results in Professor Maslin's report were run on a corpus of 1.1 million online conversations, not a sample. The two 300-post samples were used only for manual validation of the coding. That distinction matters. The purpose of the manual review was not to estimate what was the corpus as a whole, but to test whether the coding as applied to that full corpus was sufficiently accurate for a reliable statistical analysis. Defendants' 300 out of 1,129,730 ratio therefore proves nothing. They're not wrong. The relevant statistical question is whether the validation sample is large enough to estimate coding accuracy with acceptable precision. That is precisely what the margin of error calculation addresses, and Professor Maslin performed it correctly. She drew a sample at random with 100 posts selected from each of the 3 relevant time periods to ensure adequate coverage across periods with materially different posting volumes, including the periods with pronounced spikes in activity. On the negative versus non-negative classification, Professor Maslin reported that the LLM agreed with the manual reviewers 85% of the time. The margin of error for that validation result is 5.3. Put differently, the reported accuracy is 85%. I'm not sure what that symbol is, but something to 5.3%. I think it's give or take. Yeah. Which means that even at the lower bound, the LLM's accuracy is 79.7%. In other words, even in the worst case, the validation result remains at or about the level typically regarded as reasonable. Given the nature of the task and the level of ambiguity the raters face while making decisions, these figures indicate a moderate to substantial agreement between the two raters and the automated analysis. Okay. Defendants do not dispute this. On the thematic analysis, Professor Maslin reported that the LLM agreed with the manual reviewers 84% of the time. Similar to the above, the margin of error for this result is 5.5%. As such, the reported accuracy is 84%, give or take 5.5%, which in the worst case is 78.5%, well within the range prescribed as reasonable by most authors. Defendants do not dispute this either. Professor Maslin analyzed the full universe and used a random validation sample to test the accuracy of the coding applied to that universe. That accuracy is high, even when accounting for the worst-case margin of error. Critiques as to the expert's decision-making are for cross-examination, not for preclusion. Professor Maslin applied a multifaceted, self-reinforcing approach. Defendants also assert that Professor Maslin's conclusion is nothing more than observing timing, but this fundamentally misunderstands her methodology. Professor Mayslin's analysis is focused on discontinuity design, a causal inference approach that looks for a sudden, sharp change in the data. When she identifies such a change, Professor Maslin then looks for something that is also different that may have caused the shift. Here, what was different was defendants' launch of their smear campaign. Professor Maslin's conclusion is based on the entirety of her analysis, which is volumetric, sentiment, and thematic, and it is reinforced by the fact that the narratives identified in the planning documents that defendants used to launch their smear campaign appeared with great frequency during the spikes in negative sentiment directed towards Miss Lively, which provides evidence that defendants' behavior drove the shift. Professor Maslin opines that these themes were not meaningfully present before August, when they increased sharply. Defendants propound alternative explanations for the negative sentiment shift toward Miss Lively, most of which amount to some version of the argument that the public attention generated by the release of a major motion picture would have been expected to create negative attention on Miss Lively's past. Which is an argument that I have said. I think people just may not have been familiar with her, realize, oh, she's the star of this film. They've anticipated the film. They look forward to the film, possibly because of, the book, maybe because of Justin Baldoni's reputation. Who knows? But Lively has not got an A-list actress career. She has an A-list husband and A-list friends. But I think they've got, seen that she's going to be the star, Googled her, or they've seen the interviews and gone, what the fuck is this? And Googled her. And then, a million-piece jigsaw fell into place about why she was behaving the way she did around the subject of domestic abuse. And I think, they've gone, oh, right, her past. crap, she's not a nice person. We don't like her. That's what I think has happened. And that's, you know, Wayfarer are suggesting the same thing, and Lively's team are saying, well, look, that is actually an argument for the jury, not for exclusion, which they're right. It is. In any event, Professor Maslin addressed this argument directly. Marketing for It Ends With Us began many months in advance of its release into theatres, including the release of the film's enormously popular trailer in May. Substantial marketing events, including Book Bonanza in June, and significant press coverage, including early reviews in July. Yes, but location share came in August. So did that horrific junket with Brandon Sklenar and Ryan Reynolds. Indeed, Colin Hoover testified that marketing was pretty much done by the premiere in early August. The steps that follow illustrate how discontinuity design works. Despite all of this public-facing promotional activity, including considerable attention to Miss Lively while she was marketing the film, between May 2024 and August 2024, there was no evidence of recurrent negative sentiment toward Miss Lively until mid-August. Okay, so if the film premiered on August 9th, and she's saying, well, things really, like, she's citing Shusty's video, Jed Wallace, sent it on the 14th, so that's kind of the date there. But if people went to see the video, went to see the film, right, and were like, ooh, yeah, this is not what we expected, then they may have gone and Googled her. And again, location share was like August, I think it was August the 8th. It was the day before the premiere. So, and the thing is, right, is I think people, like, there's not enough, I cannot overstate how damaging that interview is for her. That is singly the worst hit to her credibility. And in the Depp Heard trial, when they were playing the recording of Amber Heard, tell the world, Johnny, tell them that you, a man, are a victim of domestic violence, and see what the jury says. And in the opening and closing statements, especially in the closing statements, they started with that. That was their opener, was to play that audio for the jury to refresh them again that this woman had basically, media where we could play videos, audio, essentially at the end, especially for the closing. If we had the ability, I would be playing the location share. I would. Because that is hard hitting, and that is going to have the same effect. And it's Lively's own words as well. Like, I mean, she cannot refute it. That's what she said. What she said. She was asked a question about domestic violence survivors. If they go and see the film and they want to come and speak to you and share their experience, literally share their traumatic experience, what's the best way to approach you? And then she launched into a joke. And then I would then from there on lead on with, that is how she's treated us the entire way, from pre-production, from amending the script. She took out all the abuse. We all saw she took out the abuse because we questioned whether there was any abuse. And then I would lead on to how she kind of undermined the domestic violence bit all the way through until now. Now suddenly she wants to be the victim, and she wants to be the voice and represent all these people she once, joked about. And that's how I would lead it, I think. Right. Sorry, I digressed there. I just had a little thought bubble then. But I'm trying to tie up, like they're saying, well, during the height of promotion, everything was fine. There was no negative shift. And yeah, because actually, if you look at the book bonanza, for instance, there was nothing overly controversial that kind of you know, like she was talking about Taylor Swift. Even when she admitted to stealing the film, like the people she's saying this to, they don't realize the magnitude of what she's saying. So there is no huge spike, but the spike did seem to come immediately on the heels of location share. So, and grab your florals. They were both in August. That is the entire arc of marketing for this film played out publicly, generating hundreds of millions of impressions of online content, yet sentiment remained stable until after the marketing had successfully led to box office success. The spike did not materialize until August, after defendants began their smear campaign, and defendants have offered nothing beyond illogical speculation to rebut Professor Mayslin's causal inference. In concluding that defendants were the cause in the negative sentiment shift, Professor Maslin considered alternative causes that is built into the discontinuity model. Therefore, defendants' arguments that Maslin ignored the strong evidence of negative sentiment against Miss Lively in her dataset is baseless. To the contrary, as Figure 12 illustrates, regardless of the chatter in May to July 2024, the sentiment toward Miss Lively remained positive to neutral. Okay. Yeah, because you're starting to see the shift here on. I can't. No, I can't highlight it. But this first, so ignoring this little, the first blue spike, the next one along then where it starts to be a series of successive blue sort of spikes there, which are nowhere near as big as the end of 2024, start of 2025, by the way. That is kind of around the time of the 9th to 11th of August. It's around that time, so I think it's before the 9th actually, so it's kind of between the 4th of August and 11th of August, which would probably put it somewhere between, well, around maybe the 6th, 7th of August. And location share video happened. Grab Your Florals was happening. So that's what seemed to happen. But I mean, look at that. That's not even a yeah, no. I'm not buying this. Besides which, as you said, Shusty's video does, contradict especially Aaron Carlotta's evidence. So, but that is the next video, so I'll get into that there. But yeah. That there was no change in sentiment until August 2024 is what matters. And don't forget, Jed Wallace was only brought on like a few days before this apparent spike. I mean, did they have the whole world turn against Lively in just a matter of literally 2 or 3 days? That's what Lively's trying to allege, and I think it's an uphill battle for her to try and prove that. For this reason too, no matter how many times defendants attempt to blame the victim in their Darbo motion, Darbo, and during deposition, Professor Maslin explained why Miss Lively was not the cause of the sentiment shift. Professor Maslin concluded that comparing the period before August to the period in mid-August, there was no discontinuity in what Lively was doing. What Blake Lively was doing was fairly stable. Yes, look, no one was talking about her. No one knew who she was. There was a bit of buzz there, though, in May 2024. I'm not sure what happened there. It might have been something to do with Another Simple Favor, even. Okay. What Blake Lively was doing was fairly stable. Professor Maslin reaffirmed at her deposition that she further reconsidered and rejected every alternative that defendants now propound again. Yeah, but she did disregard the text messages between Sony, and you can't disregard them because Sony were there in the middle of it. And Giannetti was literally there on set. Lively was talking to her. Jenny Slate was talking to her. Justin Baldoni was talking to her. So she would have been well aware of what was going on because she was there, right? She didn't see all the incidents, but neither did Alex Sachs. Neither did, apart from one incident, Jenny Slate, and neither did Brandon Sklenar. Conveniently, although they seem to happen in public places, no one saw them. But Ange Giannetti would have been, in real time part of the conversations. She was the person, the go-to person. She was who Lively went to. She was who Jenny Slate went to. And if Ange Giannetti is calling her a terrorist, then I think that's something that is actually relevant. It needs to be considered. Sanford Panich also called her a terrorist to Ange Giannetti at, a separate, different time. But again, they would have been having all these internal dialogue, because, they would have been discussing all this drama, and Sanford Panich would have been in contact with Ange Giannetti and Josh Greenstein. Similarly, defendants' argument that other negative sentiment, apart from the specific scenarios identified in the scenario planning document, arose in high numbers after August 2024 only undermines their position. To be sure, the data shows that there was a spike in many negative narratives about Miss Lively, including certain narratives that predated August 2024. But the point of Professor Mayslin's analysis is that all of this negative conversation spiked in a manner that was incongruous with the timing of the release of a wildly popular box office smash, but entirely consistent with defendants having lit the match. Once lit, the fire spread through social media, taking advantage of algorithmic design and informational cascades. In other words, amplification of the negative topics that defendants inserted into social media platforms in August 2024 led viewers to notice and engage with content and on other negative topics about Miss Lively or her brands. And once online sentiment shifted about Miss Lively and her brands, that sentiment calcified. Defendants baselessly assert that Professor Maslin is uncritically accepted company documents in opining on the decline in Miss Lively's brand equity. But Professor Maslin emphasized the importance of scrutinizing the data for any and all causes of this discontinuity. Explained that she specifically confirmed several times with the management of Miss Lively's companies, both through meetings and through documentation, such as presentations and sales data, that there were no other changes, including in the marketing of the product, in the marketing space, or the pricing, or anything else. And explicitly stated that she found nothing else that could plausibly explain this change. That conclusion makes sense. Miss Lively's brands were thriving. The hair care brand had only been launched 4 days before. How is it thriving? Miss Lively's brands were thriving throughout many of the supposedly shocking events on which defendants fixate, including during the high-visibility marketing period prior to August for the film. Yet her companies remained stable financially and operationally until they cratered. Defendant's purported smoking gun appears to be a dispute over a figure caption rather than any substantive methodological flaw. I just got to go back here again because there's yet her companies remained stable financially and operationally until they cratered. Astonishingly, at the same moment that the film delivered enormous dividends at the box office. I mean, one has to ask, right, if they saw that wig she wore in the film and were like, did realise it was a wig and thought that her hair care brand would deliver something like that. And I wouldn't go and buy it because it doesn't have conditioner. I cannot tell you how much that makes me. It makes my teeth itch just thinking about it. Like, why would you not have conditioner with a hair care range? You can't even. How can you even call it a range? I don't think I'll ever come to terms with that. Like, I rely on conditioner because if I don't, my hair looks like a bird's nest. As soon as I'm in any kind of humid environment. Anyway, I just had to digress there for a second. In her report, Professor Maslin states that a small set of repeat users posted sustained negative commentary over time, a pattern shown in Figure 19. It's interesting that Professor Maslin was able to identify a small set of repeat users who were posting negative commentary over time. But when she fired 107 shots in the form of a subpoena to content creators, every shot missed. And she came up with nothing. There was no documents, there's nothing. She literally gleaned nothing from all of those subpoenas. But Professor Maslin was able to find the people who were behind the smear campaign. Figure 19 has captured examples of repeat harassers persistently commenting and is sourced to a single page of the Blake Brown Media Impact Overview. Even accepting defendants' contention that the figure depicts only a single account, the use of plural language in the caption reflects the broader finding documented elsewhere in the same exhibit, which catalogues multiple categories of problematic accounts, including accounts engaged in harassing activity and inactive accounts engaged in harassing activity. It is preposterous to suggest that the use of a plural noun in a figure caption renders an entire expert opinion inadmissible under Rule 702. Defendants' cited cases are also inapposite in supply, and I'm not sure what that means. In this case, the expert based his report exclusively on his client's unrealistic assurances rather than available records because he relied on summaries of purchase orders prepared by plaintiff's general manager, which the court called the client's conclusory statements and not the orders themselves. The plaintiff's experts neither showed their work regarding their assumptions and relied upon information nor independently reviewed documents. Professor Mayslin's diligent analysis stands in stark contrast. She has explained how she sourced her data, how she analyzed the data, and the factors she considered as an alternative cause because it would not ordinarily be expected to cause a decline in sales. Professor Maslin also reviewed the deposition transcripts of Katie Case and Brianna Coslow and other documents to understand defendants' assumed conduct. Applying her marketing expertise and literature regarding brand equity and reputational spillover, Professor Maslin observed and concluded that because all three of Ms. Lively's brands sharply declined in sales, reversing month-over-month growth and positive sales trends, the shift in sentiment as to Ms. Lively's personal brand was to blame. Here, defendants argue that negative reviews about Blake Brown products' efficacy and formulation caused the stiff decline in brand sales. But even if such consumer complaints about Ms. Lively's brands exist, they do not explain the timing, scale, and thematic consistency of the observed sentiment shift. At best, this is a competing factual narrative, not a flaw in Professor Maslin's methodology. Professor Maslin articulated her causal inference framework, explained why she selected the time frame and baseline, and took affirmative steps to search for exogenous market forces. For both her conclusion regarding why there was a shift in sentiment and how it impacted Miss Lively's brands, and concluded none existed. That is more than sufficient. Defendants' irrelevant cases do not hold otherwise. The defendants do not like her conclusion or proffer their own. That defendants do not like her conclusion or proffer their own is not a reason to exclude it. Challenges to assumptions and omitted variables are addressed by competent expert testimony and cross-examination. And whether defendants' alternative explanations better explain the sentiment shift and result in harm to Miss Lively is for the jury to evaluate. Okay, so we've not got many pages left now. Professor Mayslin's testimony is admissible because it will help the jury to determine facts in issue. Additionally, Professor Mayslin's testimony is relevant under Rule 702A. In assessing whether proffered testimony is relevant, courts look to Rule 401 and examine whether it has any tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. Here, Professor Mayslin's testimony will help the jury determine factual questions, namely whether defendants' media manipulation and smear campaign affected conversations and consumer attitudes about Miss Lively, and whether that manipulation negatively impacted the sales and performance of Miss Lively's brands. Professor Mayslin's testimony is critical. In their own words, defendants intended for their scheme to destroy Miss Lively in the public's eye to be untraceable, and made use of ephemeral messaging platforms. However, using scientific methods, a body of evidence, and cross-comparisons of large-scale sentiment shifts, combined with emerging narratives, Professor Maslin is able to connect defendants' stated plans to bury Miss Lively with their intended outcome. Defendants insist that counsel can accomplish the same by introducing documents and testimony through fact witnesses, but that is backwards. The speculation of lay witnesses about when and how the public decided to notice and care about specific narratives in an endless sea of online content, and how that shift in attitude impacted Miss Lively's businesses, is certain to be unhelpful. I mean, at the end of the day, right, there are 5 motions to quash from content creators who are all saying the same thing. Hey, we got involved with this case, right? We watched the marketing in real time. We watched how she reacted to domestic violence, and we didn't like it. And that was completely organic. We're not being paid or anything else or incentivized by Wayfarer or their counsel. And that's just 5 people who she basically subpoenaed and invited to file something on the docket and tell us some home truths. And we did. By contrast, the use of specialized marketing statistics and economic principles through Professor Mayslin's expert testimony is quintessentially the kind that will be helpful to the trier of fact. Professor Mayslin's analysis reflects expertise and specialized knowledge, and defendants' cases are inapposite. Defendants further lodge a hodgepodge, I love that word. Oh, sounds almost British, doesn't it? Defendants further lodge a hodgepodge of personal attacks aimed at keeping Professor Maslin off the stand, claiming that Professor Maslin does not apply any expertise, recites or regurgitates content, and otherwise summarizes. None of the cases defendants cite in support bear any resemblance to the methods Professor Maslin applied. In 3 of them, courts precluded experts from testifying where their opinions were not the product of any methodology or specialized knowledge. First, the expert in Andrews improperly testified about easily observable events regarding the condition of the railroad platform, mainly that the station was dirty, filthy, and kind of icy, that the platform had trash and ice on it, and that the lighting was very dim. But the jury needed no special training or expertise to decide whether the platform was a safe place. Second, the expert in Goldstein was slotted to do nothing more than inappropriately infer one's state of mind by speculating regarding a supervisor's decision not to consider plaintiff for a promotion. Finally, the expert in angiodynamics did not conduct any specialized economic analysis that would assist a fact finder in interpreting the record evidence he relies on. Rather, he recited that evidence, drew inferences that a fact finder could glean from merely examining the evidence itself, and concluded from those inferences that the evidence established causation. In contrast with all, Professor Maslin, a leading expert in her field, applies marketing and economics principles to help the jury understand broad social media trends on a celebrity's brands and profitability. In 3 other of defendants' cited cases, the expert testimony improperly invaded the province of the jury or was otherwise unduly prejudicial. Again, features absent here. First, in Zong, I hope I'm saying that right, the testimony of the expert exceeded its proper scope, where he interpreted and vouched for the admissible evidence the government had offered by stating it was troubling and raised major red flags, and came dangerously close to usurping the jury's function by providing an overall conclusion of criminal conduct. In addition to testifying to severely prejudicial matters of tangential relevance to the case, including the history of slavery and sharecropping in the United States, as providing background for his opinions. Next, in Hayden, the court kept out testimony where an expert incorporated plaintiff's interrogatory responses, assumed a legal conclusion, and engaged in credibility determinations by frequently adopting the testimony of fact witnesses in the case to support his own opinions. Finally, in Smith, the court declined to allow the defendant to allow someone to opine as to the circumstances of his interrogation, which would be a backdoor means of putting the defendant's hearsay in without subjecting him to cross-examination. None of these are remotely close to Professor Mayslin's opinions, which omit any mention of witness testimony, parties' written submissions, or observations regarding individual motivations. Professor Maslin properly measured the harm from defendant's retaliatory campaign. Lastly, defendants contend that because the court identified certain categories of reasonable defensive measures that would not constitute actionable retaliation, Professor Maslin's analysis is fatally flawed for including social media posts reflecting those themes. In doing so, defendants fundamentally mischaracterize the court's summary judgment opinion, which is a bit rich of lively to be complaining about, to be quite frank. In doing so, defendants fundamentally mischaracterize the court's summary judgment opinion, the scope of Professor Maslin's assignment, and the burden on Miss Lively. First, the court did not hold that narratives in the scenario planning document were non-actionable as a matter of law. Indeed, the court did not grant summary judgment to defendants on any aspect of Miss Lively's retaliation claim. Rather, the court drew a nuanced, fact-specific distinction between permissible defensive measures and conduct that crossed the line. It specifically identified the scenario planning document and stated that there is evidence from which a jury could find that the Wayfarer parties planned more aggressive action, not only to destroy Lively's accusations, but to destroy her and her career. It was precisely because the scenario planning narratives could be construed as directed not at Lively's allegations and undermining her credibility, but as an attack on her professional reputation and livelihood, that the court denied summary judgment on the FIHA claim. Thus, far from non-actionable, the court found the narratives that Professor Maslin tracked sufficient to create triable issues of fact for the jury as to which conduct underlying them is actionable. Even setting that aside, defendants once again complained 2 distinct questions. 1. Which specific acts of theirs constitute actionable retaliation? And 2. Whether defendants' orchestrated campaign caused measurable harm to Miss Lively's reputation and brands. Professor Maslin addresses the latter. Her report examines whether there was a marked shift in the volume the content and the sentiment of online conversations about Miss Lively consistent with the defendant's orchestrated campaign. She linked the shift to declines in sales across 3 of Miss Lively's commercial brands. She speaks to damages, not liability, which she measures in aggregate. The damages flow from a single integrated campaign to destroy Miss Lively. Nothing defendants say shows otherwise. Defendants' cases are both non-binding and inapposite. Professor Mayslin's semantic analysis is one component of a broader analytical framework that also encompasses sentiment classification, brand perception data, and sales performance. Defendants have not revealed any methodological defects in Professor Mayslin's analysis. Her opinions reflect reliable application, will be helpful to the trier of fact, and should be admitted in full. Okay, so that's the end of that. We're going to go and do the next video on Dr. Aaron Carlotta. I can only give predictions, right? I'm not sure where I sit with Jennifer Freyd, which is why I didn't kind of sort of opine on it. So, because I don't like what she has to offer. I do think that she is overstepping, especially on any evidence, any evidence regarding emotional distress. I think there is a chance, but I don't know for sure that she could be excluded or limited. Like some of the things that she wants to talk about may be excluded, but her overall, some of her stuff will also be allowed. I don't think that either Nicole Alexander or Dina Mayzlin are going to be excluded. Again, there may be limitations, but I'm not sure. Okay, so I'll be back for Dr. Aaron Carlotta.